Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Thank you and good morning, everyone. The next case is M.J.R.B, Z.M.B, N.N.T.B, and S.B. We'll hear from the appellant.
Good morning. My name is Pete Wood, and I am the attorney for Nelson Bryant, the father in this case. He's appealing the termination of his parental rights. I'm going to speak for 10 minutes, followed by 10 minutes for Mercedes Judd, who represents the mother, and we will reserve 10 minutes for rebuttal. We're not sure how that will be allocated, depending how the argument goes. I'm under a bit of a time crunch, so I'm just not going to simply rehash my brief. I divided this, my argument into two basic categories. Number one, trial court violated my client's due process rights by summarily ruling on his three motions: his motions for a new guardian ad litem, his motion for a new attorney, and his motion for a continuance, without allowing him to present evidence. And furthermore, on the first two motions, without his lawyer or his guardian ad litem being in the room and not giving him a chance to speak. Second of all, the trial court violated his due process rights by not compensating for his disability. Mr. Bryant has had a guardian ad litem in this case since 2016 because of his diminished capacity and incompetence. And during the hearing, started a little bit after 9 o'clock, and his lawyer didn't show up till 9:30. And his guardian ad litem didn't show up till 9:45. And 2 of the 3 motions were heard with neither his lawyer or his guardian being there. And the third motion, the motion to continue, was heard without his guardian being there. So Mr. Bryant has the right to have effective representation of his attorney and of his guardian ad litem. Because of his limited capacity. And when the court, because of the importance of his due process rights, should have conducted a hearing in the presence of both his lawyer and his guardian ad litem as soon as he made those motions. The court didn't do that. At 9:09, the court initiated contact with Mr. Bryant and began asking him about the case. Mr. Bryant at that point said he wanted a new lawyer, new guardian ad litem, and said neither one had done anything for him. The court then ruled summarily on both motions. Full 20 minutes before the lawyer got there, and the court said, we're not granting your motion, we're hearing this case today. And furthermore, both the guardian ad litem and the lawyer have prepared for trial. How the court knew that when neither one of them was there and heard no evidence is not clear to me. But the court should have conducted a hearing on that.
I'm sorry, Mr. Wood, was your last statement that the way the trial court knew that they weren't, that neither the attorney or the guardian ad litem were prepared for trial was because of the time of their arrival?
I'm just saying that at that point they weren't in court, so the court had no idea what they had done. The only thing the court had heard was Mr. Bryant's request for a new attorney and a new guardian ad litem, and the court conducted no further inquiry. So at the very least, the court should have asked both the attorney and the guardian ad litem, what have you done, what's going on here, to determine if there was an actual issue with the representation. But the court just made an assumption that they had done a good job without talking to anybody. So when a parent in a TPR case requests new counsel and a new guardian ad litem, what the court should do is the court should conduct a hearing with those parties present. At that point, the court should ask questions of everybody, hear evidence, and determine if there's merit to the motion. If there is merit to the motion, the court should replace those people and continue the case. If there's no merit to the motion, then what the court should do is the court should proceed forward, but then instruct the parent on their right to proceed pro se as to the lawyer and their right to hire a new attorney. A parent does not have the right to waive his guardian ad litem. Now,
so this had been before the court. these parents, I think you said since 2016 that there had been a guardian ad litem. Is that right?
Yes, sir.
So the trial court was certainly aware of both the guardian ad litem and the attorney representing the biological father in this case, right?
Yes, sir. In fact, it was the same judge who appointed the guardian ad litem back in 2016, and the court, just through its actions, indicated it knew what the two roles were. When Miss Shutt's client tried to talk to the judge, and her lawyer and her guardian ad litem were in court, the judge stopped her and said, "Hold on a sec. I can't talk to you. I have to go through the guardian ad litem and the attorney." And so the court was new to roles. Furthermore, in this up until 9:45, the court told Mr. Bryant what the roles of his lawyer and his guardian ad litem were. So the court understood that.
The court also mentions that the respondents appeared highly anxious at the start of the proceeding. The court noted anxiety and frustration, requested that the court bailiff to show flexibility with regard to courtroom decorum. So would you agree that the court tried to accommodate some of the special circumstances of this case?
No, because I think the court made the assumption that Mr. Bryant was just being disruptive. And if you look back at the original order appointing the guardian ad litem back in 2016, the reason for appointing the guardian was because of diminished capacity and because Mr. Bryant at that point had been disruptive in court and non-responsive and interrupted everybody. It was the exact same issue going on. Furthermore, Mr. Bryant brought up the issue in his motion to continue, and he wasn't on his psych meds. He wanted a 2-hour continuance to allow him time to take his meds and calm down. He said he couldn't understand the proceedings without them. So I think that the court took actions that would have been appropriate if we were dealing with somebody who didn't have a Rule 17 guardian ad litem and the lawyer had been there. But this was a person who had issues because of his lack of meds, and this was just his baseline behavior. That's why he had a guardian. The guardian ad litem had attended every single hearing, and furthermore, the guardian ad litem had been instrumental in facilitating conversations between Mr. Bryant and other people. He would frequently go to DSS meetings and enable conversation between Mr. Bryant and the social worker. Not having a guardian ad litem and not having the attorney in court when these motions were taking place was prejudicial error per se. And I would argue that the court should remand based on that for a new hearing. If the court is inclined to find that it wasn't prejudicial per se and that we have to prove prejudice, I would urge the court not to do that. What I would say is that there isn't enough evidence on the record to show what the motions were based on because no hearings were held. As I said before, evidence should have been heard. The lawyer and the guardian should have been asked questions. Certainly the guardian could have been asked questions about, is this normal behavior for him? Is this baseline behavior? Is this due to his meds? What meds is he under? Is he taking right now? How would I help out? So we just don't have that information here. And the case, if you're not going to find prejudicial error per se, should be remanded back to the trial division for hearings on the 3 motions. Now the motion to continue.
So is it your position that when anytime an individual who has a guardian ad litem and an attorney tries to make a pro se motion with regard to an aspect of the hearing, that the trial court needs to treat that as a motion of the parties as opposed to waiting until the attorney or the guardian ad litem are present, and at that point seeing if there are motions that need to be made?
Well, I've been a trial attorney for 30 years, and there are frequently pro se motions, and they are treated as motions of the parties. However, the attorney is there during those motions, and it's especially necessary in this case where the guardian ad litem was needed to facilitate conversation to help Mr. Bryant understand the what was going on in court. Now, your point is well taken that there are motions of attorneys and motions of defendants and parents, and they're 2 very different animals. However, the court still has an obligation to hear all of those and do so in the presence of the lawyer and the guardian.
Is it your position that the trial testimony began before the presence of the GAL and the attorney?
No, the trial testimony did not begin, although before then. What happened was when the guardian ad litem finally got there at 9:45, the guardian ad litem and the lawyer went off and talked with Mr. Bryant for 10 minutes. Then the hearing started. But there were proceedings for 45 minutes before the lawyer and the guardian got there, and they affected Mr. Bryant's rights because they were pretty substantial motions. So I would just stress that the motion to continue was not heard, but I would submit it should have been granted, just balancing the interests of Mr. Bryant with the interests of the other parties. He had a strong interest because he couldn't understand the proceedings. It was a minimal delay. It was a 2-hour delay. And from my reading, nobody objected to it, and nobody on the record said what the opposition would have been based on and why it had to be referred immediately. And this is a court that had shown it was willing to continue cases. It delayed the hearing for an hour to let the lawyer and the guardian get there. And then the second hearing date, the court actually continued the whole case to a further date because Mr. Bryant was physically ill and was bleeding internally. But I need to allow Ms. Chutt time to talk, so if there's no further questions, I'm going to defer to her.
Good afternoon. My name is Mercedes Chutt, and I am representing the mother in this case, Shakelia Perkins. In my opinion, there are at least 3 significant errors at the trial level that affected the outcome of this case. 1, the trial court did not consider the special needs and abilities of each parent, both of whom had Rule 17 guardians ad litem throughout the case. 2, the trial court treated the mother's reported mental health diagnosis as probative of grounds to terminate parental rights without either verifying the diagnosis or determining how the diagnosis affected the mother's ability to parent and her ability to perform the requirements of her case plan. And 3, the trial court's termination orders do not comply with Rule 52 of the North Carolina Rules of Civil Procedure, and that the trial court did not enter proper findings of fact or conclusions of law. Now, going to the first of the concerns, I think it's important to note that both of these parents had Rule 17 guardian ad litems throughout the entire trial court proceedings. I think at least 3 weeks after the non-secure orders. And as we know from this court's opinion of N.N.T.B back in, I think, 2016, the trial court in a Chapter 7B case can only appoint a Rule 17 guardian ad litem if the parent is incompetent under Chapter 35. So incompetent under Chapter 35 means the parent lacks the capacity.
Ms. Chutt, I had understood, I believe it was Mr. Bush, to argue in the brief that the guardians in this instance were appointed because of diminished capacity rather than incompetence. He may be misunderstanding his argument, but I thought that's what I read there. I take it you disagree with that assertion, assuming that he made it. Why?
I think there's some indication in the brief that that was the understanding, but that hasn't been the law since, I believe, 2015, when there was a change in Chapter 7B statutes that pertain to guardianship.
So your response is essentially he may be correct as a matter of fact, but the law limits guardian ad litems at this point to incompetence.
Yes, the law sits roughly, and I was actually involved in TLH. I believe it was it occurred in 2015 in Guilford County, and it was, I think the opinion came down in 2015 or 2016, but at that point in time, the guardianship statutes under Chapter 7B had changed so that the guardian for the parent was no longer a diminished capacity guardian, but was the Rule 17 guardian, which refers to the definition of guardian under Chapter 35, which is the parent lacks the capacity to manage his or her own affairs or to make or communicate important decisions involving person, family, or property. So my argument is, and the trial court understood that as diminished capacity, that was incorrect. The law had a different definition of guardianship. So, and the appointment of the guardianship would be raised judicata on the issues of capacity because the law at that time required the Rule 17 criteria. And so getting back to my concerns about understanding these parents' limitations, as a matter of law, the Rule 17 guardian ad litem, the parent who has that cannot manage their own affairs. And it does not appear from the record that the court took those limitations into account or even determined what the limitations were with respect to each parent.
Can you be a little more specific in terms of what you believe the trial court should have done?
So a parent that lacks the capacity to manage his or her own affairs, can that parent go to appointments? I mean, there was evidence in the record that neither parent actually went to a lot of the appointments in their case plan. For example, they didn't go to a psychological evaluation. They didn't comply with drug screen requests. And so, first of all, I think that the court, when you have an incapacitated parent, should try to make the determination of, does the parent have the ability to understand these requirements? I mean, and here I'm sort of arguing for Mr. Bryant, which is not my client, but Mr. Bryant was illiterate. When the social worker testified that she didn't have face-to-face contact with the parents because they were angry and obstreperous, and she sent letters to inform them of case plan requirements, could Mr. Bryant understand them? Could Ms. Perkins understand them? What exactly were these parents' limitations and how do they affect their case plan? And I think it's a significant error that the court did not even answer those questions.
It sounds to me as if you're arguing essentially for the use of a different standard in instances involving parents with Rule 17 guardians than would be the case in instances involving parents that didn't have such guardians. Is that your position? And if so, can you cite me any authority that says that the trial court is supposed to use different standards in finding grounds for termination with respect to the parents in those two categories?
Okay. I think, and to answer your question, I think all of the termination grounds require the court to evaluate the parent under the parent's circumstances, particularly 1111A2. The language, whether the parent has willfully failed to make progress under the circumstances in the statute. And I think, especially with that ground, the court must evaluate the parent's circumstances. So when you have a parent who's incapacitated, the circumstance will have to include an evaluation of that. If you have a parent who's underage, and there's cases in the Court of Appeals on that, the court must evaluate that. So I think there's already a requirement in the law for the court to look at the parent's circumstances and try to determine if, under those circumstances, the parents have met case plan goals.
Is there any decision of this court or the Court of Appeals that applies the type of analysis that you're suggesting with respect to parents with Rule 17 guardians ad litem?
I'm sorry, I didn't hear the first part of your question.
I'm saying, is there a decision of either this court or the Court of Appeals to which you can direct our attention that utilizes the type of analysis that you're talking about with respect to a parent that has a Rule 17 guardian?
No, I don't think the Court of Appeals or the Supreme Court, this court has specifically addressed that type of case, but I do think that implicit in the law with respect to the grounds to terminate parental rights, especially with 1111A2, trial courts have to take the parent's capacity into account. I mean, the definition of willfulness under 1111A2 is, does a parent have the ability to comply with the case plan? And with these parents, it wasn't even clear that they did. So I'm actually at 35 seconds, so I'll just quickly move along to mental health. I think that the case that came out in December, N.R.B. ALL, is very instructive. The court in that case held that a mental health diagnosis in itself is not going to be dispositive of any ground. At least that's how I read that opinion. And I think in this case, with respect to the mother reported a mental health diagnosis. It's not clear that the court made an independent determination of what the mental health diagnosis was. And it seemed that her diagnosis was, there was not enough analysis as to how the diagnosis affected parenting. I think to support the grounds to terminate parental rights. I think we're left with a big question mark about that issue. And I'm going to now conclude because we've tried to reserve 10 minutes for rebuttal, unless anyone has any more questions.
Thank you, counsel. We'll hear from the appellee.
Good morning, Your Honors. My name is Bernard Bush. I'm the attorney for the Craven County Department of Social Services. I want to start from the top. The father is arguing that it was error for the court to rule on against his motions and against his request for a 2-hour continuance. It's our position that the court has to decide today who decides when a hearing begins. Because on this court, the parties were getting together. Everyone knew that the attorneys, his attorney and guardian litem, were on their way to the courtroom. He got up and started blurting out his request to the court. It wasn't like he stood up and he just started blurting it out. It's our position that the court hearing hadn't started yet because the attorneys hadn't arrived and I didn't go through, or the court didn't go through the pre-hearing motions. We were still just setting up. We were lucky that this was recorded because the clerk was there and had turned the machine on. But again, it wasn't a hearing in the traditional sense of the word. Now, to the extent he wants to represent himself pro se, he should be held to a standard as an attorney would. He knew his attorney was coming. So if he wants to do it himself, there was never any notice to anyone, not even to his own attorneys. There was no findings of fact. He didn't present testimony. He just started making an argument. So there was nothing for the judge to base the decision on. And what the judge said was, I'm going to have you meet with your client and your attorney and GAL. And then when y'all come out, we're going to start the trial then. When the trial started, that motion was not made to replace counsel. As far as that takes us to the motion for the 2-hour delay. It's our position that the motion was only the ruling was only that we were going to start the trial, not that no matter what would happen, she would not stop the case. They had already come, they've already made their arguments, they've already presented themselves in court. What the judge says is we're not going to wait 2 hours. But just like in a boxing match, a referee can separate the boxers and let the fight continue. But if one of the fighters displays that they can no longer go forward, they can then step in and stop the fight at that time or at any time. What we're saying is that once the trial started, the parents started participating and participating actively, and they displayed no inability to participate in the trial. In fact, if you look at the transcript on page 31, it was Ms. Bryant who made the first objection to me bringing in questions about her first set of children back in 2003. She objected. Her attorney tried to shush her, and the court sustained her objection. She was participating. On page 70, she testified that she was ready to take the stand. She was not drowsy. Page 92 of the transcript, the father informed the court of the name of the child in question because, again, rules were relaxed, so they were blurting out things. But again, he heard what was going on. He heard that the wrong child was named, and he corrected the court. Page 149, when the foster parent got up to testify, the mother stood up and left because she didn't want to hear what he had to say. not because she was drowsy, not because she was ill. When she heard that on page 115 and 116, when the social worker played the voicemail recording of her cussing her out, she then again tried to explain it. She didn't miss it because she was drowsy. She was clear enough to try to offer her explanation. And again, it shows that for those 2 hours that they said that they were not capable of testifying or participating, they were participating actively. And again, in that one case, the mother got an objection that the attorney wasn't even going to make. So there was no error in the judge saying, we're not going to wait 2 hours. We're going to start now. If anything had happened to either of the parents or even the attorneys or the witnesses that would have required the court to stop, it would have stopped. As evidenced by the second set date for the hearing, the father had a legitimate injury and the court couldn't go on, and there was no hemming or hawing. The case was continued. We had to pick another day. So we would hold that the decision to not wait 2 hours did not prejudice them in any way. At any time, the judge can step in and say, this person is not capable of going further. We're going to stop it now, and actually demonstrated that in this case. Let's see. Going to Ms. Schutz's arguments about the capacity. Again, the record reflects there was no finding of incapacity or incompetence. They were never found to be unable to manage their own affairs or communicate important decisions.
Mr. Bush, what do you say in response to your colleague's argument, Ms. Chutt, that court didn't have any authority to appoint a guardian ad litem on any grounds except incompetence?
That she may be correct. It may not have had the authority to do it, but it did it anyway. So that would be an improper appointment. But again, that doesn't go to the fact that there was never a finding of incompetence. The court, it was wrong. They probably, following her line of reasoning, should not have appointed a guardian ad litem. But there was never a finding of incompetence.
Well, where does it leave us if we have a guardian ad litem that was appointed in the absence of a finding of incompetence?
Unfortunately, it leaves us in a situation where that person may not be paid by the LC because it was a proper appointment. But the clients were not harmed by the presence of this guardian ad litem who tried to earn. And I think all of the other grounds that they spoke to, Ms. Schutz's argument speaks to the courts making decisions in the absence of medical documentation of the mother's limitations. She refused to go. That the court considered. So the decisions to terminate was not based solely on the mental health diagnosis or even on the diagnosis at all. The court did not terminate the parents' rights because they suffered mental health issues. They refused to drug test. Their visits were stopped because they were threatening at the visitation center. They weren't suspended. They were just stopped until they got a letter from their doctors stating that it was safe to proceed. They didn't do it for 3 years, so it wasn't suspended. It was held up until it wasn't terminated. It was suspended. I'm sorry. But had they had gone to a doctor and got a note saying that they'll behave themselves or they're not a danger, the visits would have restarted. They never restarted. They didn't do anything that was requested of the social workers. At the termination trial, that was when the mother announced to the court and everyone that she took parenting classes on her own and that she had went to port on her own and she presented her bottles of meds. These things were not presented during the 3 years prior where her attorneys, the court, the guardian ad litems, or the social workers could do something to put them in a better place to get their children back. They didn't. They left us on our own. For the adjudication hearings, they did not appear. And as was found in the second adjudication hearing of Sue, a year had gone by since the first adjudication hearing. The social workers didn't know where she lived and only was able to find her because she was giving birth to Sue. That's how we knew where she was. The hospital informed us. And a year into the case with the other 3 children, she tested positive for cocaine. The baby tested positive for cocaine. If that's not an indication that on their own they weren't making progress to reunify, nothing else would. And I don't want to read my brief. I think it covers it very well. So at this point, I would like to stop and either entertain questions or turn it over to Mr. Armbruster.
M.J.R.B here on behalf of the guardian ad litem for the children, and I'll proceed. We did not file a separate brief. We filed a brief joinder DSS. So I just, based on the argument this morning, I just wanted to address a few points that I've heard raised during this argument. I wanted to bring the court's attention to this issue that Mr. Wood has raised for the respondent, Nelson Bryant, about the request to have new counsel. It is very clear from the transcript and from the court's order that the court gave every accommodation it could to the parents in trying to get this hearing conducted. And there's many instances in the transcript of one parent or the other interrupting the court, and how to interpret that. It's been interpreted in the father's brief as being that he made a motion to dismiss his attorney, and the court chose to treat it that way. But it's not like he basically makes comments to the effect, they haven't done anything for me. That's sort of common to what he does in the transcript. So in the outset of the order terminating parental rights, the orders, the court does reflect that that was made and that it found good cause to deny the motion, and noted that, I think Chief Justice N.N.T.B noted earlier in the argument, that the respondents appeared highly anxious, etc. I also wanted to bring the court's attention that the court does make some findings of fact later in its orders that I think also supports its decision there in terms of its decision on counsels, in findings of fact 166 and 167. And I haven't seen any argument in the briefs to show that there's not evidence supporting those findings of fact. So just briefly, finding of fact 166 notes that only with relaxed rules of courtroom decorum, patience, and flexibility were the respondent parents able to sit through and allowed to continue to participate in the trial process over a period of 3 intermittent days. The respondent's parents appeared to struggle with trusting counsel and act on their behalf despite their efforts to present their best defense. And then finding of fact 167, and this is based on the totality of 3 days of hearings, as I understand it. 167 says, quote, "This court is impressed with the preparation and presentation of evidence in the trial of the issues before the court. The attorneys for each party demonstrated professionalism and compassion for the issues and the parties. A lot of effort, compassion, resources, and hard work have been put in this matter with this family." And I do believe that the transcript has more than enough evidence to support those findings as regards to how the court ruled on the motions raised in the father's brief. I would note that that's somewhat similar to one of the supplemental cases of authority that was cited by Mr. Wood in his supplemental filing. That's the In Re TLH case that I think is an opinion from 2015 that I think Justice Ervin, you authored. But in that case, that case was about whether there should be a substitute parental GAL appointed in that case. And you go into there's some depth in that opinion discussing the reality that we need to be deferential to the trial court, as that is the trial judge, unlike the members of the reviewing court, quoting the opinion, actually interacts with the litigant whose competence is alleged to be in question, has a much better basis for assessing the litigant's mental conditions, and that's available to the members of the appellate court, which are limited to reviewing a cold written record. So I think that's just a reflection of the standard that applies here, and that I do believe that the evidence that was before the trial court and the recognition in the TLH case is that unless there's evidence to the contrary, that we should defer to the evidence that's before the trial judge on that issue. And it has been noted in passing by Mr. Bush and the parties that this is certainly all these cases are, difficult sometimes to review the facts, but I found this one, particularly difficult because, the issues that the court was having to deal with. The guardian ad litem testified that they'd been with the parents, they'd been, visiting the children for about a year and a half, and that the children had showed much improvement when he first started meeting with the children. They were very emotional, and two of them were having more issues than others, but they'd had a lot of improvement. And he testifies that in one of the early meetings, one tried to bite him, but over time they had really acclimated to their placement and were doing very well. And he was pleased with that and supporting the termination petition. He was asked, the guardian ad litem was asked whether he'd ever met with the parents, and he had not. Because, as it's noted in the record, the parents at that point had not done anything and had not been able to meet with the children for over 3 years. So the guardian ad litem had not had an opportunity to meet with the parents because they hadn't made any steps to allow those continue. I think there were 2 visitations very early on, but because of all the facts of the record, that didn't continue. So it's noted in the record that the mother declined drug screens 16 times. This was, it's not a case where a parent tried to make some steps. The amount of effort here was really, very, very minimal. So I think that all supports the court's findings. So I just wanted to supplement Mr. Bush by saying we agree with the decision of DSS to support the termination and ask that the court affirm the termination. And I'm available for any questions that the court may have.
Thank you, counsel. Rebuttal.
Yes, sir. I'll take about half the rebuttal time. So in response to petitioner's argument that the hearing hadn't started, court was going on, it was recorded. The testimony may not have started, but the court still should not have initiated a conversation with Mr. Bryant. These weren't just spontaneous comments he made. The court was asking him questions and he was responding. And even if it hadn't started, as soon as the lawyer and the guardian got there, the court then should have informed them of his motions and given them a chance to respond, because they knew the case better than the judge did. And the judge couldn't simply, based on his motion, summarily deny it. I would submit that he's not a pro se litigant who's held to the same standard as anybody in court. He's not pro se. He has a lawyer and a guardian. That's the whole point of this. And they should have been there. And the other thing is that even a stopped clock is right twice a day, right? We're not going to rely on a stopped clock. So pulling out isolated moments during a 3-day hearing to say, he's competent here, he's competent there, because he made a statement, doesn't mean that Mr. Bryant could proceed without a lawyer, without a guardian ad litem, because these isolated moments are not indicative of his mental health status. He's illiterate, he can't read and write, he's on psych meds, and the court determined that he had a habit of spontaneously uttering out comments and interrupting court, and that's why they appointed the guardian in the first place. In petitioner's brief, petitioner also argues that this was all some sort of delaying tactic by my client. There's no evidence of that. No statements by the court, no statements by any party, no findings of fact that it was a delaying tactic. Petitioner and the court and everybody here today is under the same disadvantage. We do not know what the record would have shown if the hearings had been held. So we can all speculate, but that's not evidence. We just don't know. So I would ask the court to vacate the order terminating parental rights and remand back to the trial division with instructions to dismiss the petition to terminate parental rights because of the gross miscarriage of justice that was done at the beginning with my client's due process rights being systematically violated. And if the court's inclined to find that prejudice must be shown, I would ask that the case be remanded back with instructions to hold a hearing on the 3 motions, because we just don't have any evidence at this point, because the court summarily ruled on all 3 motions. And I will defer right now to Ms. Shutt if there are no questions.
If it pleases the court, for rebuttal, I'm most struck by the comment that the trial court did not understand the standard for appointing a guardian. Was a guardian diminished capacity? Was a guardian incompetent? Was a standard incompetency? If the trial court did not have an answer to that question, I think that that is a profound error. And I think it's an error that justifies reversal. As the court found in N.N.T.B, it's the trial court that has to make the determination of the parent's capacity and the parent's need for a guardian. And so here we appear to have the DSS attorney arguing that the court may have made a mistake. Well, when it comes to terminating parental rights, something that the parents have constitutional protections against, I think it's very important, it's crucial that the court understand the standard it was using in appointing a guardian. It's crucial for the court to know if the parents are incompetent under Rule 35 or if they have a diminished capacity. If the court did not have an answer to that question, how could the court terminate parental rights? How could the court evaluate whether the parents made reasonable progress in their case plans, had the ability to make reasonable progress in their case plans? So I think that that is an error that requires reversal.
When was the guardian appointed? 2016?
The guardian was appointed in September of 2016. I think at one of the initial, at a non-secure hearing, a continued non-secure custody hearing about 3 weeks after the children came into care, the oldest 3 children.
Are any of either of the appointments of guardians through the court's order, any of those orders contested?
I do not believe so.
Have you made any argument that the presence of the guardians harmed your client in any way?
I'm sorry, I didn't hear the last part of your question.
Have you made any argument that the presence of the guardian for your client had any adverse impact on her chances of prevailing?
I think no, because it's so hard to tell in the record what the guardian did and did not do. I think that's just a question mark. I don't think there's enough evidence. There's just not evidence of what the guardians did. I mean, were these like drug tests and so forth requests communicated to the guardian? We don't know. Were requests to go to counseling and so forth communicated to the guardian? We just don't know. So I think there's a need for more evidence, which I would, at least argues in favor of, remand and vacating the order. And I also want to point out very quickly that talking about my client's mental health, in, I believe it was a permanency planning hearing or review hearing in December of 2018, my client, and there's an order in the file, took some psychotropic pill bottles out of her purse or whatever, put them on the table and said, I'm taking medication. And then after that hearing, there was a finding that she signed a new release form to allow the department to access her treatment, her psychotropic treatment. And it does not appear that the department even tried to get those records. There was a release. And if you look at page 136 of the transcript, there's a testimony of Nicholas Collins, who was a social worker. He was asked, he said, the question, and you testified in your examination by Mr. Bernard that you were aware that the respondent mother was prescribed medication. Is that right? Answer, I'm not certain. Okay, she didn't tell you that? She didn't, or was she refusing to take her medication? I'm not certain. Question, did you look into who was providing her or prescribing her medications? No. How many months were you on the case before the petition of termination of criminal rights was filed? Or before that, well, he said, I would say at least 3 months, I believe. I think he was on the case 3 months before the hearing occurred. But anyway, I think there was enough time for that social worker to at least get the records that were available by the release, and he didn't. And that's one of the reasons why also I put in my memorandum of additional authority the more recent case of N.N.T.B, where this court held that, where the standard is clear, cogent, convincing evidence, the petitioner does not meet his burden, where the petitioner's evidence is an absence of records. And, in this case, you have limited parents, an absence of records, and uncontroverted evidence that the department, at least after 2018, could have gotten the records and did not. And I don't think that, so everything with mental health that goes to incapability, 1111A6, it goes to fitness of parent, 111101. I think they all falls apart when it comes to my client, if you can't, if the records are not there. It's just a piece of missing information. So I would argue in summary that we are arguing for reversal of this termination order.
Thank you, counsel. Thank you, everyone.
Thank you.
Clerk.
Oh, yes, oh, yes, oh, yes. The Supreme Court of North Carolina will be in recess until the next calling of the calendar. God save the state and this honorable court. All right. Thank you,